1 of the Court of Appeals is now in session.
Good morning. Please be seated. Now is the time set for oral argument in cause number 1CA IC 17-0068. And I've wondered this since I first looked at the spelling. How do I pronounce Danial? Daniel? Okay. So it's, I'm going to call it Cardock Danial, petitioner versus the Industrial Commission of Arizona. For everybody's information, and as I know isn't a surprise anymore, these proceedings are being both audio and video recorded. So as long as the equipment works, you'll be able to see yourself on YouTube in a couple weeks. I hope it works out well for you. Counsel, each side will be entitled to the standard 20 minutes. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will attempt to not take up your time, all of your time, but there are no promises. So ultimately, that's up to you. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and the issues. You might want to keep that in mind. We tell people that so you can figure out if we've read it today and if we looked at the facts today, how much time do you want to spend on facts, how much you want to spend on argument. Use it as you will, but you know we've referenced it and addressed it this morning. Counsel, when you come to the podium, each of you, I would ask that you state your name and who you represent. And with that, counsel for the appellant.
Thank you, Your Honor. Good morning. My name is Bob Wisniewski, and I represent the applicant below, the petitioner herein, and the taxi cab driver in this case, Mr. Daniel. Thank you very much for the opportunity to be here this morning and to speak to you in oral argument about where I think the administrative law judge in this case made a legal error. The judge did find a great deal of facts in this case, and I respect that judge. But if we look at the decision, at the end of the decision, I believe that she made critical errors in this case. As we present the case to the court, discuss it with Mr. Lundmark and the honored guests here today, I intend to point out those deficiencies. She said it was a close call, and I disagreed with that. And she said also that the cab company, and I'll use AA or yellow cab interchangeably, or the cab company, said they exercised some control over the taxi cab business. But at the conclusion, she said, but the cab company exercised very little direction or control over the details of the applicant's work. If we look at the Post versus Industrial Commission decision, it tells us we've got to find out how the judge got to that conclusion. And I think she laid out all the facts, and then all of a sudden we jump to the conclusion. Where was the analysis? It would make all of our jobs a lot easier if we could have figured that out. But it probably doesn't make any difference in how I present the case today, because this court has to make its own independent determination of the legal standard, and I think the judge failed to apply the appropriate legal standard to the facts of this case. She ignored the Anton case. She had ignored central management. Let's look at this thing that's called the taxi cab agreement that's attached as, I think, one of the first exhibits in my appendix. The respondents call it a lease. Mr. Lundmark will tell you that they're simply in the leasing business, that AA or Yellow Cab just leases cabs. My client pays $920 a week, almost $3,700 a month to lease a cab. These folks are not Hertz.
Sorry.
Hertz. These are not Hertz like a normal cab company.
Hertz.
Yes, thank you,
How
Your
does
Honor.
that fact weigh in your favor, though? If the lease rate is very high and there is no guaranteed compensation, doesn't that actually tend to suggest an independent contractor status? Because the economic substance of the transaction is that there's a significant investment by the putative employee with no guarantee of compensation. That seems to be the essence of private business, not employment.
That's an interesting question. I'll respond to it this way. That does not allow any autonomy. There is so much that the applicant has to do to get over that $3,700 hump each month. So he can only get through that utilizing AA Cab's contract with the city of Phoenix. He can't work autonomously.
Wait, there's no autonomy on his part? He has no selection, no choice?
Not correct. The contract allows him to go work elsewhere if he chooses to. But because they meter the credit card through the cab company's meter, and they take their lease money off first before he gets paid every week, he has to get over this huge hump. If he goes out on the street, he can't earn that kind of money. He has to go to the airport where he is designated to go, and that's where the business is and the business travelers and the large amount of money.
That just describes the reason for the dollars in the transaction. AAA is providing a license, if you will, to do business on city property. They have that license. They're charging for it. But how does that make your client an employee?
Makes my client employee because he has no other way to pay for this unless he goes through this airport construct that the city that the AAA has. They have the contract with the city. They have the permits. They have the license. My client has no licensure as a cab company. The AAA is licensed by the city as a cab company.
So, counsel, you look at the lease arrangement as an indicia of control that would indicate employee? That alone, the lease arrangement?
Yes, Your Honor. I believe that the lease arrangement itself, and it's not a lease. If they wanted a lease, they would call it a lease. But they call it a taxi cab agreement. And Mr. Lundmark will tell you they're in the leasing business. They're not in the business of simply leasing an automobile like I could go to Hertz, rent a car, and go off and rent a car and do my own cab business. They're furthering their operation as a taxi cab company by running it through the city of Phoenix at the airport.
But don't we have a continuum of control? Let's say on one end we have AAA has their own cabs and their own drivers, and they go to it. And then we move in the direction of independent contractor. Isn't that when things like lease agreement suggest that indicia of control is at least lessening?
I think it's the exact opposite. If you look at their taxi cab agreement, all the things that they control, they tell this gentleman that he has to turn in receipts every week. He has to turn in a log of his mileage. He has to show his receipts for gasoline. They can fire him at cause without a standard of what is the cause. They provide the meter. They maintain the vehicle. And they make $6 million off these 140 drivers.
Well, counsel, he doesn't. Your client doesn't even have to answer for all the money that flows through his cab. I mean, you're saying he's an employee of the cab company, but as I remember, and correct me if I'm wrong, the briefing indicated that while he had to report all of the credit card receipts, that he keeps the cash.
Your Honor, that's correct.
Okay,
He keeps
so
the cash.
so what we've got is an employer who says, listen, you work for my restaurant, anybody that pays in cash on the table, I don't need to see that. I just want to see the credit card receipts. I don't know of an employer that does that. That sounds to me very much like they're taking their costs for the lease of the cab off the top, and then the rest of it, including the cash in his pocket that he doesn't even have to tell him how much it is, goes to him.
The bulk of the business is credit card.
Bulk or not, give me another company that says, listen, anybody that comes in and pays in cash, you get that one freakish circumstance where someone buys $10,000 of materials and pays cash to you. We're not concerned about that. You just keep that. Give me something like that.
I think in this case, this is an integral part of the business of AAA. In other words, what he does, what he driving that cab and earning the money for this exorbitant lease, this is essentially an indentured servant. He has to pay almost $4,000 a month to rent a vehicle.
So anytime we have a lease, well, actually, I have a better question. What could AAA have done here to set up an independent contractor arrangement?
That's an interesting question, and I don't think there's anything they could have done. I think it's much like the question of how much more control could they have over the situation when the administrative law judge says they didn't have enough control. What more control could they have over
There must be
the situation?
something they could do. Uber and Lyft, I assume you wouldn't argue that those drivers are employees, but maybe you would.
Well, I think that's not in front of me this morning, but I think in terms of
That's why
answering
we
Judge
do
Weinsweig's
hypothetical
question,
questions.
I think there's probably a different way to set this up, but not under the circumstances that are in front of us.
Well, there's a different way to set it up for an independent contractor relationship. Agree?
They would probably just lease the cab to them, period, if they're a
Okay.
leasing company.
But don't they have, if they're the owner of the cab, I got to believe they have certain concerns about liability if someone is DUI in one of their cabs, right?
That's correct. They provide liability insurance on the cab. They also maintain the cab.
So they protect themselves.
They protect themselves.
In the course of this arrangement where he doesn't even have to report, gets to keep all the cash.
Correct. But he has to control, the control that they have is all of these other indicia. He has to provide, bring the cab in for inspection. I go to Hertz and rent it. I don't have to do that.
Aren't we back to the same thing? If I own that cab and I'm leasing that sucker out, I'm going to have it in as often as I need to make sure that the wheels aren't going to fall off out in the street. So to the extent that he's paying and they're servicing that equipment, it sounds to me like that's what an entity would do that was a leasing agent that was leasing these to people who then had the right to assert that they were legitimately on the street.
I think there's a difference, Judge Jones, about protecting the property and controlling this operation. They work through the City of Phoenix. The City of Phoenix sets forth these obligations. They pass through. The use case tell us anything that passes through in terms of a regulation of, they were real estate agents. Those folks were held to be employees because they were doing the obligations of the real estate department. Here we're doing the obligations of the City of Phoenix. Mr. Lundmark will say, well, we had nothing to do with this. But this is a multi-million-dollar business. And the only way to protect these individuals is to keep them as employees.
I'm not sure that you keep saying that AAA makes a lot of money and that they charge a lot of money. I'm not sure that the quantum of money involved matters at all. Is that one of the factors we need to look at?
I think that's one factor to look at it in terms of,
Where do we find that in the law?
I think it's the bargaining power. In other words, this is a contract of adhesion. These gentlemen that drive have no other way to just sign the contract and move on.
I hate to look at facts outside the record, but one can go to door 8 of Terminal 4 South and find plenty of alternative ways that drivers can make a living.
But these folks have to pay a huge lease, and the only way they can pay their nut is to go to the airport on a daily, almost 10-hour-a-day basis.
So why would we focus on the leverage? It seems to me you're emphasizing this leverage, that you have a hook, that AAA has a hook in these folks because they owe this great expense, and so they can throw any conditions on them that they want, and that's why we have the relationship of an employee rather than an independent contractor. But isn't the important point in this indicia of control analysis the actual control? Don't you say, well, they have to wear a uniform? Why are we so? Where in the cases is it talked that we look to the leverage that results or allows you to exercise control rather than the control itself?
You have to look at all of the facts. In this case, they train these folks. They endorse their application.
That's the control
Right.
itself, right?
And all of the elements that are in that taxi cab agreement and that are replete in the briefings. Those are the elements that give the right to control, and that makes this the integral part of the business of the AAA.
Can I ask you a few factual questions?
Sure.
Does AAA dispatch calls to your client?
No, Your Honor.
Okay. Does AAA control where your client can pick up fares?
Not they are controlled in the extent that he must go to the airport and pick up airport. After he picks up airport, he's free to pick up somebody else.
Okay. I assume that there's a fare schedule that AAA adopts and that applies equally across its cars, but I may be wrong about that.
The fare schedule in this case is set by the Aviation Department of the City of Phoenix.
Not by the putative employer.
Correct.
Okay. And you say there is a training program.
They trained Daniel.
Okay.
Who's they?
AAA. The Yellow Cab trained him.
There's a dress code, but that's imposed, I believe, by the City of Phoenix, not by AAA.
The contract also says the taxi cab agreement says they must dress professionally with the class of the vehicle.
So they must comply with the city ordinance.
But the fleet manager said that they can discipline those people even outside of the city requirements if they break certain rules. And the city fleet manager also told us that this is an asset. The contract with the City of Phoenix Aviation Department is an asset of AAA.
And is there anything wrong with an asset holder hiring independent contractors to carry out portions of their responsibilities?
Not if they let them simply just be independent contractors and freely independent, not controlled in the fashion that was controlled here in this. It's very hard for them to be autonomous because they tell them, AAA or Yellow Cab tells them all of these requirements that are in this agreement. They have to perform the contract, and the city, they're performing the contract for AAA with the city, and they said that they couldn't do this without these people.
So,
and I think
let's
that's
talk
the
about
Anton
radio,
case.
the dispatch. There is no dispatch.
They go to Lot C at the airport, and the airport dispatches them to the location where they're supposed to pick up.
But there's no ongoing dialogue between your client and AAA through a dispatch.
Not specifically. They are required to carry the AAA two-way radio in their vehicle, so they have the right to control if they chose to exercise it.
Do they have the right to refuse a fare?
Yes. No, I'm sorry. Excuse me, Your Honor. They cannot refuse a fare. In the agreement, it says they cannot refuse a fare, they cannot refuse a customer, or they'll be subject to termination or discipline.
But does AAA have the right to say, well, we're not giving you a fare? I suspect not, because AAA doesn't give fares to its drivers, correct?
They don't share in the fare. They don't share in the fare. They don't assign a fare. You're correct, Your Honor.
Yeah. The word fare is a little ambiguous. They don't provide referrals to passengers.
Correct.
Okay.
Does AAA have any voucher program?
They have a voucher program. They have a discount program. And
Tell me about the voucher.
They give out vouchers so that the drivers get paid less, or they get the money for that. So that my client then gets a credit for the voucher or a credit for any promotional fares against his lease when they settle up each month, each week.
So the compensation is similar to central management. It's fees
Exactly.
as they come in the door, and then the occasional voucher.
Right.
What sort of interaction does your client have with AAA on a daily basis?
They just show up and work every day
Where do they show up?
at the airport.
Okay, so they don't. It's not like the show Taxi. They don't go to the garage and pick up their cab and drink coffee. And
That's correct.
Talk to the manager. They take the cab home. They go to the airport.
Right. They get the cabs from the cab company if necessary. It may not very well be the same cab each day. It differs. But I think the controlling cases, in addition to central management and Anton, is the West Virginia case that we cite, C&H, that talks about how interwoven the gears are to make the money for the cab company. And how they can't discharge their money to get the exorbitant amount of money on a lease unless they have these workers and they control the gears of this production to make sure it works smoothly.
And you're saying there's no way that could be done by independent contractors?
Well, it very well may be, but not under these circumstances, not under this case.
If there were one fact, if you were on the other side and there were one fact you could change to make this more independent contractor-like, what would that fact be?
There would be a simple agreement that says this is a leasing arrangement, period. That's it. You're here to just lease the vehicle.
Don't they have a contract that says, no, strike that. Go ahead. I'm sorry.
I'll reserve whatever remaining time I have. Thank you.
Good morning. My name is Todd Lundmark, and I represent AAA Cab Service and Travelers. Let me begin, if I may, with an observation. When Mr. Danial had his accident in May of 2016, he had been working as a cabbie for over 14 years. During that time span, the cab company paid him exactly nothing. He paid the cab company for the use of the cab. He worked at the airport, which credentialed him and dispatched him.
I take that as the fact that he was paid nothing as an interesting and potentially significant fact. But how do you square the significance of that with central management?
One of the factors in central management was the same. This was a lease arrangement, as long as the claimant in that case...
That driver was paid nothing, right?
She was paid nothing, and that was one factor in the case. She paid $52 a day, and she kept everything she brought in as fares.
Right.
Right.
And here the lease rate is higher, but one might be inclined to find the fact you began with dispositive. And yet central management not only didn't find it dispositive, it came out the other way.
Came out the other way for a lot of different reasons, and I still get hung up in these cab company cases with the fact that the putative employee is not being paid anything for the services. In any definition of contract of hire, the idea is there's some exchange of services for pay, and we don't have that in this case.
Are you saying central management is wrong?
It's an odd twist in that case, but it's just one of many factors that I think would distinguish that case from this one.
Counsel, can you give me a list, and talk as fast as you want, I got YouTube. What is different about the arrangement here as compared to the arrangement in central management?
Central management does figure very prominently in our case. We haven't subordinated the citation to a footnote, so we understand that that's a big issue for us. Here are the differences as I see them. Let me just list them for you. In central management, the drivers could only drive for that company, whereas in this case, it's undisputed that the drivers had the right to work for anybody they wish to. The driver in central management did not have an agreement in place that specified who was responsible for workers' comp benefits, whereas in this case we do. It's that taxi cab agreement. In central management, the company set the rates, and I agree with you, Judge Swan. Sometimes the word fare gets confusing. Fare can mean customer, fare can mean rate. I'm going to try to avoid the confusion. But in central management, the company set those rates. In central management, the company set a formal dress code. Here we went no further than asking the people to dress professionally. Central management conducted formal performance reviews. We never did anything like that. But the most important feature in central management that distinguishes that case from the facts of this case is they had a dispatch operation. They were in constant communication with those cab drivers, and as the court noted in its opinion in central management, that was the way that they disciplined and controlled the drivers. We don't dispatch anybody at the airport. The airport handles all of the dispatch operations. Those are the key differences as I see them.
Anything else you want to share?
Those are the ones I could come out.
Those are the ones. Okay.
Yes.
All right.
Yes.
So
You used the term dispatch and control drivers. That's what you said just now, right?
Yes.
What control was exercised over the drivers? Define the control for us, if you will.
In central management or in this case? In this case.
Yeah.
There really was no control other than to send them to the airport. We had a lot of conversation in the case, a lot of testimony about in what ways AAA could control the activities of the drivers. In her award, the judge said, on the whole, AAA exercised very little control over the drivers. That's obviously not the test. It wasn't.
Isn't that typically a standard provision in an employer-employee arrangement? They strictly control the activities or the conduct of the employee?
Yes, certainly. That's what divides an independent contractorship from an employment relationship. To what extent are we controlling the details of the work? And in this case, my ALJ was not convinced that they crossed that line. The right to control test does not provide that the punitive employer has the right to no control. We have enough right to control to get the achieved result. And the question is, did we ever cross that line? There are a couple of ways that AAA could have gotten involved in the control here, and I want to break them down. There's one category that I would say is a matter of common sense. Dress professionally. Keep the cab clean. Obey the traffic laws. Don't drive drunk. Do those things even need to be said? I guess to the question, what could we have done to make the contract even stronger? Maybe we could have said something along the lines of, our experience shows that if you keep the cab clean, you're more likely to get a tip, but it's up to you. You're your own person. I don't think we needed to say that. So that was one category of control, and it was almost de minimis. There's another category, though, and that's what distinguishes this case primarily from central management, and that is these were airport drivers. They were credentialed by the airport. They were dispatched by the airport. They operated under the airport's rules. They could be suspended by the airport after a hearing. Our folks were somewhat involved in that process. I'm not going to overstate the
Part
case.
of the process.
They were aware.
Making the rules, enforcing the rules, interpreting the rules, what were they involved in?
They did not create the rules. That's strictly up to the airport. They had no role in that. The testimony of the fleet managers was that AAA imposed no rules that were different from what the airport imposed. That was the testimony of the fleet managers. And the testimony of our fleet managers was 95% of the discipline meted out to these drivers was all from the airport,
What was
not
it,
from
90
AAA.
what?
Pardon?
What was the percentage?
95%.
85%.
That was either the testimony of Jack Gilmet or Jonathan Payne,
Okay.
the two fleet managers. That's what really makes this case different. Do we have an interest in making sure the drivers are competent to drive at the airport? That's part of our contract for the city of Phoenix. But once they get to the airport, they're under the airport's control.
So
They're
are you
dispatched
saying
by the
that-
airport.
Are you saying there's direct corollary that says 95% of the instruction, rules, direction, however you want to define that, is meted out by someone other than the AAA or whoever?
Yes.
So that being the case, that's 95% of what would otherwise be employer control that isn't exercised by the cab company itself. It's exercised by a non-associated, if you will, entity, public entity.
It's by the.
Is
by
that the analytical approach you're saying? 95% indicates such a strong percentage of the control that's required, and it's meted out by the city of Phoenix. Is that where you're going with that? That it's not the cab company?
It is the city of Phoenix. And our people made that very, very plain, that the city of Phoenix is controlling these operations.
Let me piggyback on that then. I understand AAA has three types of drivers. Is that
Correct.
accurate? You have the airport drivers, you have this medical driver, and then you have a driver that, they drive all over Phoenix, but not to the airport.
So yes,
Is
street
that
drivers.
accurate?
Street drivers, airport drivers, and non-emergency medical transport drivers.
So
The latter,
the street drivers for AAA, if I'm reading your argument right, are employees.
they are treated as independent contractors as well. They all sign the same.
But they don't have that 95% sort of government gloss of regulation. What? And they have a dispatcher, I would assume?
They are dispatched by AAA. They are not under the airport control. That is a significant difference between the two, and our fleet managers made that point. They accepted that. But
What
our
about the
case,
first point you had, which was the difference between this case and central management? You said that in central management, the driver could only work for one company, whereas here, you can moonlight, you could work for. How does that work its way into the control analysis?
well, that's evidence of absence of control. How many employees can pick up and work for somebody else today rather than for me, the employer? That's a significant difference.
Isn't the analysis that they're not free to contract with someone else? That the cab company itself in central management precluded their employment by someone else?
Yes, they, as I understand the facts of that case, they were required to work only for those cab companies owned by that one company.
But then isn't the argument here that it takes so much effort to pay this rather high lease payment that as a practical matter, moonlighting isn't realistic?
Don't know that we have an answer to that from this record. What I would say, and this was going to be my opening observation, is this. Here's a guy who worked for this cab company as an airport driver for 14 and a half years. Unless he was completely irrational, he apparently found this arrangement to be to his economic benefit. And why is this even relevant? It gets to one of the points raised by Mr. Wisniewski. Yes, we do use a kind of scorecard for these cases. We have a column for evidence of independent contractorship and one for employment. And sometimes we can lose the bigger picture, which is, are the parties permitted to avoid an unwanted employment relationship? That's really what happened here, and it worked to their mutual benefit as far as we can tell. I bristle at the idea that this was a contract of adhesion. We talk about subbing out the integral part of our
I'm not sure that's an issue
business.
before it.
But I want to come back to one thing that I think may be important for you. We had a couple of hearings in this case. First hearing was in April of 2017. The claimant testified. Jack Gilmet testified. The former fleet manager. By then he was retired. We had the second hearing in July of last year, July of 2017, and at that point the claimant's brother, Danial, testified, as did our current fleet manager. The Daniels, of course, took the position that they had no idea that the cab company was treating them as independent contractors, even though they both agreed that they signed the taxi cab agreements. Between the first and second hearings, there could have been no confusion about what was going on here. And certainly in Daniel's case, he had to understand the position that we were taking, that we were treating him as an independent contractor. And despite all of that drama, by the time we got to the second hearing in July of 2017, Mr. Daniel was still working for this company. I suggest that that's evidence that this was a workable business relationship that should be promoted, two parties operating at arm's length. Certainly if Mr. Daniel thought it was a bad deal economically, he could have found another job.
Maybe I spoke too soon in saying the contract of adhesion analysis wasn't before us. If you're going to say that these are freely negotiated contracts between people of equal bargaining power at arm's length, I would ask you how many drivers have ever successfully negotiated a term of one of these agreements?
Talking about contract with the City of Phoenix?
No, with AAA. I find it hard to believe, but you may correct me, but I find it hard to believe that drivers come in with counsel and sit there and go through the terms of the agreement and redline them to their specifications. I think these are uniform contracts.
They are, and I'm not suggesting otherwise.
Okay. So then when we talk about the idea that it would be nice if people could design their own relationships, I think the law looks on that concept with a little bit of a jaundiced eye because of unequal bargaining power between employers and employees. I'm not suggesting that this isn't an independent contractor relationship, but I think the mere fact that people recite that this is the relationship they want is one of the least important factors.
I guess my point, Your Honor, is simply this. We have a lot of talk about how this was a difficult financial relationship for these guys because they had these lease payments they had to make every week, and that's true. And I'm not suggesting that they had the right to go into the owner of AAA Cab and say, you know what, I need to redo my deal. But they did have the right to find some other employment, some other engagement if they wish.
Right, but take it or leave it doesn't mean that you're an independent contractor. A lot of employees face take it or leave it deals too.
Not in and of itself. The point I'm trying to make, though, is there was some equal benefit here. Why else would Mr. Daniel continue working for this company for as many years as he did, paying his own taxes based on his 1099s and based on his own record of his cash receipts, unless he was doing pretty well? I think he was.
Is that relevant?
Or if it's relevant under Anton, isn't it just a factor?
I'm urging it as a factor, and I'm trying to suggest that the mere fact that the company is operating through independent contractors is not inherently wrong. And I would cite to the court its own decision in a case called Reed versus Industrial Commission handed down some years ago involving a commercial truck driver. This was clearly the business of the moving company, but it was doing all of its work through independent contractors. The moving company was imposing rules that were required by DOT and other federal regulations, and in that case the court found that the driver was an independent contractor. It is appropriate to work through independent contractors if other criteria are satisfied.
So let me ask you about this dispatch factor or fact. So are you familiar, and I understand it's not in the record, but with Uber and Lyft?
Yes.
Okay, and are they independent contractors?
I think that debate rages, Your Honor. I don't have an answer for you.
Okay.
Well, if that debate rages, then a fortiori, this debate should be raging, right? Because if the appellant here is an independent contractor, the Lyft and Uber cases should be no-brainer.
I don't know that I'm in a position to compare a traditional cab company's business model with Lyft and Uber. They're completely different animals. Lyft and Uber are basically working off platforms. That's the argument in those cases, as I understand it from casual observation. This is a traditional cab company working through its cab drivers, treating them as independent contractors for good financial reasons.
But the putative employee here, much like Lyft and Uber, at least as I understand it, does not have the right to say, gas prices are going up, and I'm feeling pretty good about my driving today. My mileage rate is going to go up today. I'm going to charge $5 a mile today. Couldn't do that, right?
I don't know in the case of Lyft and Uber, but I can tell you in this case.
In this case, couldn't do that.
We don't set the rates. The airport sets the rates. We have nothing to do with the rates.
When you were distinguishing categories a while ago, and we all understand there are three categories of drivers. The medic drivers are employees.
Yes.
I don't know what else to call them other than this, the pickups on the street.
The street drivers?
Street drivers, that'll work for me. The street drivers and the airport drivers are not employees. Why was it determined that the medic drivers would need to be employees while the street and airport drivers were not? Where did they part ways?
Judge, I don't know that we have anything in this record that discusses that issue.
Would you agree that the case for independent contractorship, though, might be stronger with regard to the airport drivers and the street drivers?
Yes. Oh, absolutely. Yes. And that's our position today.
Was it an issue? Do you have any idea if it was an issue of liability where the medical import of the moment was something that had to be recognized?
If I had
I'm a
to
driver, I'm not taking
speculate,
that on myself.
I think it might also deal with training because you're basically moving people who cannot transport themselves, medical patients, from one facility to another. I think that requires different licensing, different training. I think that's the answer.
Just real quick, going back to the fares, you have no word on the fares? I thought that the city sets the maximum fare, and you set the AAA the fare. Is that not accurate?
AAA does not set the rates.
You have no word in, no say into that.
The city sets the rates. They set the maximum rates.
The city doesn't set the rates arbitrarily, though. I'm imagining AAA has some input into that process. Probably has a very strong interest in what those rates are, and I can't imagine that they never picked up the phone and suggested what the rates should be.
I suspect they have an interest in the rates. I don't know what they do to negotiate the rates or if they have anything to do with them. That was not part of our record. But they have nothing to do with the rates. There was some evidence that the drivers, if they wish, could charge less than the maximum rate. Not sure that anybody ever does that.
What about the rates if the putative employee here is out and about and picks someone up on the street?
We did have testimony about that, Your Honor, and the evidence is that they were subjected to the rates set by Weights and Measures. They have nothing to do with those rates either.
So he couldn't just cut a deal on a street corner and say, you want to go up to Carefree, it's going to be $100.
Those are controlled as well. according to our record.
Only by governmental entities?
Correct.
Okay.
Correct. Not by AAA. All right. Thank you very much.
Thank you.
My brief moment or two left, I would just like to urge the court to take a look at the central management case and look at the decision in that case. They tell us that CMC, Central Management, was not simply leasing vehicles which coincidentally were used as taxi cabs. If that's all we did and stopped there, we wouldn't be here today. It was in the business of operating, maintaining, controlling, and presenting the public a fleet of cabs for public transportation. That's what this taxi cab agreement indicates. They have got signs on it. They have their logos. They have everything on it that says AAA or yellow cab. My client can't do anything to alter that. This is the image of AAA. This is the image of yellow cab. And they are presenting that to the public. And as a consequence, that integral part of the business is the Anton rule, that they are subcontracting in the heart of their business. Their people told us that. They can't do it without people like Mr. Kardash.
If you'll indulge me, let's go through these. We only have a little bit of time, but these 7 factors that distinguish this case from central management. Does it matter that central management, you had a driver that could only drive for one company, and here it's limitless?
It is limitless only in the contract, but not in practicality, as Judge Schwan said earlier.
Does it matter?
I think it does matter.
Okay.
In other words, our
It
client.
does matter to the analysis.
Yes, it does.
Okay. And then what about the dispatch, the absence of dispatch and an ongoing dialogue between would-be employee and employer under your argument versus no dialogue?
I think it's a neutral factor. The city sets this up. The city does the dispatching through their lot. AAA or Yellow Cab buys into that. That's the deal they have with
How do
them.
they buy into that?
That's part of their contract. They are discharging the contract with the city under the terms that the city sets up. And to do that, they can only use these people to do that. They're not doing it independent. They're buying into the requirements that the city set up.
I see.
Thank you very much. I think
Thank
my
you.
time is up. Thank you.
Council, thank you for your time, your energy. Thank you for your input today. We are going to certainly take time with all the things you've told us today. At this point, we're going to conclude the proceedings. We're going to adjourn and take the matter under advisement. Thank you.